The only way that helping kids embrace their God-given sex through counseling can be made out as this professional misconduct is if it's settled science that sex can change, and that clearly isn't true. And as we've seen here, Colorado's own argument makes that obvious.
Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Joseph Clement, Content and Program Manager at Napa Legal.
You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. So this week, we're going to start by covering the oral arguments in the Chiles versus Salazar case, which, if you have not been following, is the basically compelled speech case involving gender conversion therapy in the state of Colorado. Then we'll move to a lawsuit in Idaho concerning Idaho's abortion trafficking laws. And then we'll finish quickly with a pro-life, pro-family program that has actually survived and thrived in the state of Michigan. So let's start with Chiles versus Salazar. Anybody who's following the Supreme Court is familiar with this case. It's probably one of the most prominent cases going up for the coming term. And the oral arguments happened on, was it Tuesday, Joseph? Okay, so
it was Tuesday,
October 7th. Now, again, I think most people are familiar with this, but we'll give a quick background on the case, then I'll give a couple of thoughts on the oral argument and what I found interesting in the way those arguments went. So the basic posture around this, it involves therapy and what therapists are allowed to say in the state of Colorado. So the statistics, the data is becoming increasingly clear that a lot of young people that experience gender dysphoria, or at least symptoms of gender dysphoria, during childhood or the teenage years come to accept their biological sex by the time they reach adulthood. So many professional counselors do work to assist kids with this process, right? Teenage years, youth, it's a difficult time, and kids need to grasp the sense of their identity, who they are. And so this process, when therapists kind of help them along in this, is often called conversion therapy. We do tend to put that in scare quotes, conversion therapy, because you're not really converting anyone so much as just helping them to accept who they are. But Colorado and many other states specifically ban this practice of quote unquote conversion therapy, regardless of whether parents consent or want that treatment, and actually require that any counseling with minors who have gender dysphoria symptoms, that the counseling affirm these distorted beliefs of sex and gender, namely that these transitions to other genders and so on are legitimate or good or to be affirmed. So that's the posture of the facts. Kaley Chiles is a therapist in Colorado. She filed a challenge against Colorado's law, which was passed in 2019 originally. And her case was just argued, when you're listening to this, it will be last week before the US Supreme Court. So oral arguments focus largely on two pieces of the issue. One, whether the speech of a therapist is protected by the free speech clause, and whether conversion therapy is fit for restrictions based on the current medical consensus regarding how effective it is. We'll get back to that because that's probably the bulk of what I want to talk about. So in the oral arguments, Chiles' attorneys argue that the law should be subjected to strict scrutiny as a free speech violation, especially because it engages in viewpoint-based discrimination, right? It's one thing if a law just precludes a certain subject of speech, and that's still going to be suspicious, obviously. So if it was just therapists can't talk about LGBT issues, for example, that would be one thing because it's not viewpoint based. It's getting rid of an entire topic, but scrutiny against compelled speech or prescribed speech issues are the scrutiny is at its highest when the discrimination is viewpoint based. When you're saying, okay, when you're talking about this issue, you can talk about it this way, right? Gender transition is good, but you cannot talk about it this way, that you should affirm your biological sex. So viewpoint-based discrimination is clearly what's going on here. And so Chiles' attorneys argued that, for one, the law should be struck down, and two, that given how serious and urgently damaging this law can be, not for therapists, but for kids in the state of Colorado who are trying to be, healthy in their identities. Because this is so urgent and so potentially damaging, the Supreme Court should rule to prevent the enforcement of the law immediately. So the court's expected to release its decision. It will probably be one of the later term decisions, so we would assume June 2026. but the oral arguments are now done. So a couple things I want to point out. First, this was argued as a straight free speech case. We've covered this before. 303 Creative, also a Colorado arguably compelled speech case, was also argued as a free speech issue alone. And it's interesting. It's worth highlighting this. There are clearly religious exercise issues involved, right? Because generally the therapists are not only asking to speak, but are asking to express their views on sex and identity in accordance with their Christian beliefs. But the challenge to the law was based simply on a violation of Chiles' free speech rights, not her free exercise rights, because the conversion therapy ban is such a clear viewpoint-based discrimination against speech. I think the approach makes sense. It's probably a winning argument. But it is always worth pointing out that this reveals a strategic decision to approach such cases as just speech cases rather than free exercise as well, because you can, of course, argue both. And there are trade-offs to that. On one, free speech gives you a wider freedom, right? For even people who are maybe ethically or morally opposed to certain practices, they can still be protected by free speech protections, but not necessarily religious exercise protections. On the other hand, is there a certain danger to avoiding the religious aspect of some of these questions and just focusing on a straight, sometimes secular speech argument? Not a decision for me to make, but it's just worth pointing out that litigation shops that are doing this kind of work are increasingly looking at free speech, free expression, rather than free exercise when trying to expand and protect some of these rights. So let's dive into just a couple of things from the oral arguments. For one, I think it's interesting to point out that the way that these laws, the Colorado law in particular, is framed is rather problematic, right? If these were restrictions that were, for example, banning and it would still be problematic for the record, but if there were restrictions that say like, okay, if somebody comes into your therapy practice who identifies as LGBT and they just want to talk, you can't impose conversion therapy, right? You can't proactively say, oh, well, your LGBT lifestyle is bad and you should be doing this, right? That would still be a First Amendment issue because it's still a free speech issue, but there would be a stronger case, right? That's like professional conduct that maybe the government has some interest in weighing in on. But that's a hypothetical. I still think that's hugely problematic. But in this case, the law goes far beyond that, right? What this law covers is even if someone comes to a therapist seeking quote unquote conversion therapy, right? If this is somebody who's identified as a gender other than his sex for years and is realizing that this is problematic to his mental health, he wants to go back and affirm that he is in fact a man, and is seeking that conversion therapy to help him accept who he is. The counselor is forbidden in Colorado from speaking in such a way and is forced to speak in a way that adopts a certain viewpoint about the goodness of LGBT identities. This is clearly viewpoint-based discrimination. It's clearly compelled speech, because at a certain point you're saying, if somebody walks into your office and wants you to talk about a problem from a certain lens, you're not allowed to. You must talk about it in the way that the secular culture views the LGBT identity issue. I would just say, I think it's pretty shocking to see a law that actually requires therapists to speak in a way that conforms to a certain politically charged vision of the human person, right? This is not just about medical evidence, and we will get to that in just a minute. So here, it's worth pointing out that there's only really one way that Colorado can defend this law and that it could survive, and that it's what the state is regulating would have to be cast not as speech, but as professional conduct, right? So if the state has very little room to regulate speech, especially on contentious political or religious issues, governments have a lot more ability to regulate professional conduct, right? The standards with which surgeons perform surgeries, right? Things like that. Of course, that's not a free speech, right? You don't have a free speech right to use like a dirty scalpel in a surgery, right? Clearly professional conduct and not speech. I'm obviously using a silly example, but it's important to point out because the only way that you can defend this law as not violating the First Amendment is if you can reclassify what's at issue here as speech. As conduct rather than speech. So I just wanted to point out, I find this whole attempt to cast this as professional conduct ironic for a couple of reasons. First of all, the professional conduct the law regulates is speech, right? Like, this isn't one of those on the fence. Is it speech? Is it conduct? Does it fall within the purview of the free speech clause? It's literally speech. It's about what a therapist can say. Like, this isn't even close to the line. So it just seems to me like a sneaky attempt to get around the free speech requirements of the First Amendment. And second, I would say, so the Supreme Court has often, let's grant that this maybe is not so much speech. It kind of looks like professional or conduct, right? The Supreme Court has cast a very wide net into what forms of conduct or expression are now falling under the free speech clause, right? Like, there's the famous case that Justice Scalia, I believe, wrote about that burning the American flag is protected speech under the First Amendment. Personally, I think that's questionable. I think burning a flag is not speech. It might be expression, but it's not what we mean by speech. There are a lot of cases where the Supreme Court has broadened the definition of speech to include types of expression that are not speech. So I think it's just kind of ironic and kind of funny that if there's clear precedent that certain conduct counts as speech, then certainly what's at issue here, which is actually speech, should be protected under the First Amendment as speech. So I don't want to repeat myself, but I do think it's kind of funny that attempts to cast this as conduct that is not within the purview of free speech is a little absurd, because it is literally words being spoken that are at issue. So during the oral arguments, Justices Sotomayor and Jackson did seem to be open to this idea that the government clearly retains the right to govern medical standards of care, right? Justice Alito pushed back, though, on this narrative, and I think he talks particularly about the suspect way that this standard regarding conversion therapy is being regulated. So I just wanted to quote one thing. In the oral arguments, Justice Alito asked the lawyers from Colorado, have there ever been times when medical consensus has been taken over by ideology? I thought it was it's a powerful question, right? Because basically what the argument comes down to is, look, says Colorado, if we're not regulating this type of therapy and banning conversion therapy, then children aren't going to be affirmed in their LGBT identities, and suicide and depression and anxiety and all these things are going to go up, right? So we have this interest in governing this professional conduct, and the problem is that's not the medical consensus, right? Like, there are certainly medical papers and things claiming that, but it is by no means a consensus. It is by no means clear that conversion therapy that is helping children to embrace the identity of who they actually are is bad for them. And Justice Alito cites, after he asks this question, an era in which medical professionals believe that children with Down syndrome should be placed in an institution shortly after birth, right? So medical consensus, okay, maybe. How much of a consensus there is questionable, but does that mean that the government should just impose it because enough medical professionals are saying it? There are times clearly where ideology has taken over the sanity of the medical profession, and in the LGBT world, that is certainly the case, right? So Justice Alito asks those questions, and then also seems pretty convinced, as did I think a few of the other justices, that the Colorado law pretty obviously amounts to discrimination against Chiles based on viewpoints that she wants to express through her speech during therapy. Alito said this is blatant viewpoint discrimination, so I think we're pretty clear on where he's going to land on the vote. So I guess I will just kind of end with that and turn it over to you, Joseph. I'll just say, like, the 2019 law, just to sum up what I've been saying, in Colorado was justified as a response to, quote, a growing mental health crisis among Colorado teenagers and mounting evidence that conversion therapy is associated with increased depression, anxiety, suicidal thoughts, and suicide attempts. So, as Justice Alito pointed out, highly contestable claim, right? This is not a case of regulating a dangerous practice outside the bounds of medical norms, right? Surgery with dirty instruments. This is about the enforcement of an ideology on the therapy profession, and it's by no means clearly medically necessary or the indisputed consensus of the medical profession. So I think it's going to fall. We discussed this offline. I think there's a small chance that you get like a unanimous decision with one of the left-leaning judges writing a concurrence saying that professional conduct can be regulated, but this one seems to be across the line in its speech. But My guess is more than likely this will follow 303 creative and we'll have a 6-3 majority in favor of Chiles and the law being stricken.
Yeah, so I'd love to spend a little more time on one of your last points about this being quote unquote medical consensus and the difference between regulating professional conduct versus speech. And to start, I'll read a quotation from the oral arguments that's worth highlighting. So one of the attorneys during arguments stated, "The harm comes from telling someone there's something innate about yourself you can change, and then you spend all kinds of time and effort trying to do that, and you fail." Now, this sounds, like a pretty typical argument somebody makes against efforts to convince kids that they can become a different sex to quote unquote transition. And the problem with doing that is sex is innate and cannot change. Trying to convince a child that they can pick whatever sex they want, it's just going to end up damaging them. Now, this quotation that I read came from Colorado's attorney. This is attorney who's defending Colorado's ban. And this gets to your point about the debate over whether this ban is just governing a highly questionable medical standard of care. The only way that helping kids embrace their God-given sex through counseling can be made out as this professional misconduct is if it's settled science that sex can change, and that clearly isn't true. And as we've seen here, Colorado's own argument makes that obvious.
And I just want to point out one, because we care about language and proper use of language at Napa Legal and on this podcast. So I also just want to say that I've used terms during this discussion like biological sex, which I actually dispute that we should even be using that word, because we often say like, oh, it's not about your gender identity, it's about your biological sex. But saying biological sex actually infers that there is biological sex, what you are in your chromosomes, and then some other kind of sex, which is wrong. So actually the proper term is just your sex. You're a male or a female, and there is no other distinguisher that is in any sense real. So just wanted to give a disclaimer there that I use these terms only because that's the way the courts or the legislatures are using them, but there's just sex.
Yeah, no, absolutely agree. So with that, we'll move on from the big headline oral arguments at the Supreme Court to one that won't get quite as much news coverage, but still has a really big impact. So next, we'll be discussing an active lawsuit that's impacting a very major pro-life advocacy organization. So we'll start with the case, then move into some subsequent disputes and religious freedom questions. Idaho has abortion trafficking laws. Now, these laws prohibit adults from obtaining abortions for minors without the child's their parents' knowledge and consent. These laws define the crime of abortion trafficking as procuring an abortion for an unemancipated minor, or, and this part will come up later, quote, recruiting, harboring, or transporting, end quote, from the law itself, a pregnant minor with the intent to obtain an abortion for her and conceal that abortion from her parents or guardians. Now, there's an active lawsuit called Matsumoto v. Labrador against these laws that recently reached the Ninth Circuit and is currently on remand back to the district court. But in this suit, some pro-abortion groups sued Idaho's Attorney General, that's Labrador, claiming that the anti-abortion trafficking laws are vague and contradict the First Amendment as speech. At the trial court level, the federal district court granted an injunction prohibiting the enforcement of these anti-trafficking laws. This decision basically said that the pro-abortion groups were likely to succeed on their First Amendment and their vagueness claim. So, as they should have, the Labrador and the AG's office appealed to the Ninth Circuit, and the Ninth Circuit upheld in part, reversed in part, and remanded. And right now the case is back on remand. So just to kind of briefly explain the circuit's opinion, or the circuit's ruling, they said that the abortion groups are unlikely to cede on most of their claims, specifically the vagueness and express association claims against the entire law. But they've ruled that in the affirming in part, the Ninth Circuit ruled that the abortion groups are likely to succeed on a free speech claim, specifically against that recruiting part of the law. They said that that's a protective form of speech. So the abortion trafficking laws I mentioned, part of it that it bans is recruiting a minor to obtain an abortion. They said that's a form of protected speech. You can't regulate it. But they severed that from the rest of the statute. So at the end of the day, the Ninth Circuit upheld most of the abortion trafficking ban, except for the recruitment part. And then they sent it back to the district court to reevaluate the case based on that. So right now, the case is back in discovery at the trial court. And that case itself is really important, but some of the religious freedom questions come up in this next part. And this is where the National Right to Life Committee, NRLC, has started to get involved. So NRLC, for anybody who's unaware, is a pretty major pro-life educational and advocacy group. They have a very large network of affiliated state organizations. And in discovery right now at the district court on remand, NRLC was subpoenaed by the pro-abortion group's attorney. And in the subpoena, the attorney demanded, quote, all documents, end quote, that were sent to and received from legislators regarding these abortion trafficking laws that are being challenged in the Matsumoto case. And the big news recently is that NRLC objected to these requests, again, probably as they should, on a number of pretty compelling grounds. Most relevant implicates the First Amendment. NRLC is arguing that the compelled disclosure of political associations, so the subpoena saying you have to tell us all of your conversations, you have to disclose all these private associations, that compelled disclosure has a chilling effect on the freedom of association that's protected by the First Amendment. Basically, when members of political organizations, especially ones that are so polarizing like those related to abortion, when those members are forced to disclose private conversations, that disclosure will make them less likely to engage in conduct that's protected by the First Amendment. So why are we covering this? It seems like a pretty niche and granular topic, right? It's an objection to subpoenas in a district court case on remand. I don't know how much more kind of minute you can get, but there's two main reasons we're covering this, and they're both pretty weighty. For one, NRLC is a massive organization. They have several thousand, I think 3,000 plus state affiliates. They have a huge impact across the country. They're very active, very, very strong in their beliefs. And the reach is large enough that any legal challenge they're facing is going to impact a lot of pro-life organizations and individuals. And second, as kind of the broader implications, this is a great reminder of a really big topic before the Supreme Court right now. And it's instances of pro-abortion groups targeting pro-life and anti-abortion groups through the use of subpoenas. Right now, the Supreme Court is waiting to schedule oral arguments on First Choice v. Platkin. In this case, the New Jersey Attorney General, basically through a series of different escalating attacks, including Consumer Reports and different things against this pro-life resource center First Choice. These attacks culminated in a subpoena asking for all of First Choice's confidential donor information. Like basically anybody above a certain threshold of giving, First Choice would be forced to disclose their name, address, all of this personal identifying information. And what these cases together go to show is that at least hopefully we hope what will happen, is that pro-life organizations have the same right to operate and conduct their affairs just like everybody else. That there's nothing in the law that lets them be subjected to potentially illegal requests from hostile actors. So it's a great example of a pro-life organization standing up and saying, no, we don't actually have to comply with something that violates our constitutional rights. And yeah, we have to be treated in the same manner. We have the same legal protections as anybody that doesn't share our beliefs. So Frank, I'll hand it off to you. I'd love to hear your thoughts a little bit on this.
Yeah, this is interesting because it's been a while since I've actually practiced in the world of civil litigation and lawsuits, and I have never gotten into something obviously this big and granular personally, but I think it's an interesting conflict about the subpoena question, first of all, because on one hand, of course, you have a constitutional right to speak to, write with, communicate with pretty much whoever you want about most topics, right? On the other hand, if there's a lawsuit, subpoenas, depositions, other kinds of discovery documents to get a hold of documentation that, including correspondence often, that the other side has that's relevant to the case is pretty normal, right? Like, do you have the right to have conversations via email or text with your friends? Of course. But if you get sued, you can't claim the First Amendment and say, like, well, I'm not turning those over if there's a dispute about, like, somebody told a lie or somebody formed a contract with that person. If the messages are relevant, they're part of the court case, right? So it's touchy. And I think, and again, I didn't dive into the actual filings here. I just read the remand order and a little bits of this case. But I imagine that the issue here is not so much that National Right to Life just has a right to speak with legislators, period, and that any opponent in a lawsuit has no right to touch those. I think the argument is that these are not relevant, right? Like, you can always object to a subpoena or a request for discovery with, it's vague, it's overly broad, right? You're asking for more than is necessary to resolve the dispute. So the way I'm looking at it, I mean, if this is going back to the district court as a challenge to whether this law violates the First Amendment, right? Whether a ban on recruiting, harboring, or transporting a minor to another state with the intent to conceal abortion, if that's the law that was passed, whether National Right to Life had conversations about that law being passed with Idaho legislators, to me, I don't see the relevance. Like, even if they did, even if they're like all in on it and they're, pushing, oh, we could use this to move the pro-life cause for, okay, fine. I don't really think that has anything to do with the constitutionality of the statute. So again, I'm not an expert. I don't have inside knowledge into what's going on here, but I would guess that on remand, this is actually the argument is quite a bland one about whether the discovery request is relevant to the case or whether it's overbroad and actually is just fishing for documents that will do exactly what you said, which is chill speech between politicians and lawmakers and pro-life organizations. Yeah, and the other thing I would say is I wonder if this would also, you had mentioned that, if there's free access to these kinds of conversations between pro-life organizations and lawmakers, and they're easily discoverable in a lawsuit that maybe doesn't have much to do with those correspondences. Is it going to make it less likely that pro-life organizations will want to engage in these conversations? Yeah. On the flip side, I would say also, is it going to make legislators less likely to want to engage, right? If you have legislators should be talking to all constituents, but if they know that like some back and forth emails between them and a pro-life organization that might make headline news are going to be discoverable in a lawsuit, even if it's like a pretense to get a hold of them, does that make legislators less likely to want to engage on the pro-life issues when it's such a hot topic? Wouldn't be surprised about that either. So I suppose with that, we can briefly head into our last discussion item, which this is great. This is one of those ones that it's not legally complex. We just want to highlight it because it's good news and a good program, and I think could be a model for other states. So here, there's a Michigan-based program that supports new families with babies with some financial assistance. Now, the program's called RX Kids. It's a project led by doctors from Michigan State and University of Michigan, two colleges that often don't cooperate, especially during football and basketball season. But the idea of this program is that they provide unconditional funding for new and expecting mothers, period. So enrolled families that qualify receive $1,500 during pregnancy and $500 a month through their baby's first birthday. The only requirements to enroll are an ID and an ultrasound. So it's just a program to support families with new babies. This RX Kids program uses both private and public funding. The idea, of course, is to combat poverty and support families who are going through often the financial difficulty, but also just the emotional and familial upheaval of adding a baby to a family. So RX Kids was launched in Flint, Michigan last year. And in that city, there are some statistics since then. Preterm births have decreased 18%. Low birth weights have gone down by 27%. The idea being there seems to be a correlation between this support of new pregnant and new mothers and lowering, having healthier babies. Lower problematically early births are going down, birth weights being too low going down. Great. It's really interesting to see that there's of course correlation and causation don't necessarily go together, but it does seem that this is producing good results in its first year. So the legislative director at Michigan Right to Life, Genevieve Marnin, recently noted that mothers in these kinds of circumstances are more likely to choose life when they have the support of their local communities. So we wanted to highlight this because, of course, we want every pro-life law, any way that we can reduce abortions is a good thing, right? This isn't about getting the right words on the books. This is about helping more mothers, families to choose life rather than to choose death for their unborn children, period. That's what the pro-life movement is about. So of course, we want to have legislation on the books that protects abortion, that protects pro-life efforts to ban abortion altogether, right? But sometimes that's not possible, right? We've seen pretty expansive abortion bans in places like Florida and Oklahoma and Texas where there's a political appetite for it. In Michigan, abortion is considered a constitutional right, right? So efforts to ban abortion by law are very hard. It's an uphill battle. There's really not a political appetite in a place like Michigan, at least not now until the culture shifts. So every effort to ensure that more women have their babies and fewer women have abortions is something that we should support and applaud. So in a place like Michigan, you're not going to get an abortion ban through. You're not even really going to make headway, I don't think, on banning late-term abortions, things like that. It's very hard to regulate. So especially in a place like that where there's so little appetite, it's great to see a creative program. It's like, okay, well, if struggling poor women who don't feel like they have a choice are the prime people who have abortions, a program like this that gives them the financial support that they need to be able to choose life, it's a victory. It's probably one of the most effective ways to offer community and financial support to mothers who are in trouble. It's probably one of the best pro-life movements that you can make in a state where abortion bans just aren't on the table.
Yeah, absolutely. My first thought when reading about this program was that I wish my home state of Virginia had the exact same thing. This sounds like a great way to support um, new and expectant families. And like you said, Frank, being pro-life doesn't stop after a baby's born. If we're going to take the moral obligation to protect life seriously, we need to have an infrastructure in place to support new families and babies, not just combat dangerous laws and policies. So yes, this is great in states where there's a hostile environment regarding pro-life laws. It's also great in states where there isn't a hostile environment against pro-life laws. Florida should have something like this, where not only are they making it more illegal for somebody to procure an abortion in the first place, they're making it easier for people to have kids. And like you said, this is a really creative way to save babies and promote families in hostile environments. In Michigan, like you said, abortion, I think all the way up to birth, was recently passed as a constitutional amendment a few years ago. And passing legislation in a place with such a terrible environment regarding life is, like you said, it's probably not going to happen. So pro-lifers need to be creative in places, again, that promote the sanctity of life, and in places like this that disrespect the sanctity of life.
And I'll just end by saying I know that it is often a fraught issue for like economic libertarian types who generally don't want government programs spending money on anything, which I will say I'm not an economic libertarian, so it doesn't bother me so much. But the general thing is, listen, government spending, first of all, on philosophical grounds, is legitimate for the promotion of the common good within constitutional restrictions, right? But the reality is we have massive welfare programs anyway. If we're going to reform them, reforming them around actually supporting the creation of families and the having of babies seems to me to be the right way to do that. So the reality is we're not chopping welfare programs or government benefit programs away 100% anytime soon or likely ever. So in the meantime, I think it makes sense to reform them to make sure that they're actually pro-life and pro-family rather than actually often promoting the opposite.
Yeah, no, absolutely. If we want to have an episode about the philosophical foundations of government and what good it's intended to be oriented towards, that might be great fodder for another episode. But
Yeah, I think that's right, but that's not today. So I guess we will end on that note, and we will just thank you as always for joining us for this episode of the Napa Legal Podcast. So if you enjoy the content we're putting out, we appreciate it if you would like the podcast, subscribe to our channel on YouTube, Spotify, or wherever you're listening. You can also get our podcast now directly on our website at napalegalinstitute.org, where you can also make a donation to support our work and help us to keep doing what we're doing. So we hope you'll join us next week as we continue to highlight and discuss the most important ongoing legal issues that affect religious liberty and particularly the work of faith-based nonprofits. We'll talk to you next week. Thank you for joining us, and God bless you.